Hi. So I want to talk more about that Supreme Court of Canada case dealing with the two teachers and their Google log. The important thing about this case is that the Supreme Court affirmed the decision of the Court of Appeal of Ontario, and the Court of Appeal basically said, we have to be careful about people's private communications with one another, even if they're expressing judgment about other employees or the school or the principal, whatever it may be, where there's an obvious intent to make sure that the document is secure and private, as it was in this case. Ultimately, that was the guiding light, that it's not just the biographical core, it's the reasonable expectation of privacy in the communications. And the Supreme Court of Canada considered this and agreed with it, but it also added another texture to this, in that a lot of the cases dealing with these workplace privacy rights and social media arise in a criminal context. This was not a criminal context. It was a charter case involving the two teachers, but did involve charter principles. And the Supreme Court said, hey, we got to be careful about expecting the criminal cases to shed the light and lead the way on employment and other civil cases. It could be an important factor, but it's not necessarily the determinative issue. That the court should always look at the competing interests, the competing values, what's the employer's interest, what's the employee's interest, and make a decision as to whether there's this inherent right of privacy. Generally speaking, if it's shown the communications are intended to be private, go to the biographical core or go to something entirely intended to be personal, likely it's going to be protected. But the bigger issue is why would anybody in any sane world today communicate on the company's IT system about anything close to personal thoughts? It used to be, days ago, two people would go have a beer and talk about what an idiot the boss was and the company's going downhill and how much they hate it there and blah, 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 and nobody would ever know. But now, with social media, text messages, and WhatsApp and the like, which we'll discuss briefly coming up, it's crazy to create a footprint about these personal communications on the employer's server. You got to be insane. So don't do it. It's something that you just should never even consider. Again, it doesn't matter if you're using the company's IT system and logging on to your own private email server, Gmail or Hotmail, whatever. Don't do it. They can follow you, even illegally. They can determine your password because every keystroke is being examined, even illegally. It ain't worth it. Don't do it. Be smart. Be aware.